On behalf of the World Intellectual Property Organization, I would like to start out this panel with our warmest wishes for today, the World Intellectual Property Day, April 26th, and this year's theme is Creativity, the Next Generation. And over the last 2 days, we've discussed the evolving challenges in ensuring that the intellectual property system achieves its aim in stimulating and diffusing creativity and innovation. This panel will discuss some innovative mechanisms developed in public-private partnership. And we have a very different, diverse perspective represented on this panel. So I'm quite honored with the speakers on this panel, and if I may introduce them, I'll start with my far left, Mr. Afam Ezekude, the Director General of the Nigerian Copyright Commission. His appointment as Director General in 2010 was preceded by over 20 years of experience in compliance, enforcement, and risk management gained in the UK. So he really covers, currently as a Director General, the public sector's perspective, but has 20 years experience in the private sector as well. To Mr. Ezekude's right is Ms. Catherine Prel. Catherine heads the IP brands relations at eBay, and she's responsible for the legal division that is dedicated to relations with IP rights owners. Prior to joining eBay in 2007, Catherine was in private practice and also worked in Amazon and Yahoo. Next to Catherine is Ms. Marianne Grant, Senior Vice President at the Motion Picture Association of America, and she's responsible for delivering all aspects of MPAA's global internal IT functions. And in addition to that, she helps to design and advocate for the association's strategies related to internet service providers' outreach activities globally. And last but not least, she serves on the board of the U.S. Center for Copyright Information, which is a new program that has been launched in public-private partnership, and I think she'll be discussing that more in depth. Next to Marianne is Mr. Ikhyun Seo, one of the founding members of Cho&M Partners in Seoul, Republic of Korea. Ikhyun has been recognized as one of the leading intellectual property lawyers in Korea by Legal 500, Chambers, Managing Intellectual Property, World Trademark Review, as well as others. And in addition to his private practice, Ikhyun has been serving since 2003 as a panelist for domain name disputes administered by the World Intellectual Property Organization. And last but not least, to my direct left is Mr. Wadi Madi, Vice President of the National Federation of Consumer Associations of Morocco. Mr. Mehdi is also a member of the Consultative Commission on Medicine and Health Products under the Ministry of Health in Morocco, and frequently speaks about the rights of consumers and counterfeiting. And I would like to note with really particular appreciation to Mr. Mehdi's presence on this panel and at this Congress, because he's really here to represent the perspectives of the consumers whose interests, efforts such as this global Congress are aiming to protect. So we'll start with Mr. Ezekude, please.
Right, good morning, everyone, and His Excellency, the Secretary General, thanks for inviting me to this all-important Global Congress 2013. I've been invited to give a presentation on the effectiveness of public-private partnership in the area of addressing piracy. And the purpose of my presentation is to highlight the efforts that the Nigerian Copyright Commission has made over the last 2 years in addressing the issue of piracy in Nigeria in the context of its corporate plan and strategy, with special reference to the public-private partnership, the strategic partnership with the private sector. For the benefit of the audience, I would just like to give a brief background of the Nigerian Copyright Commission and a brief overview of the Nigerian creative industry. The Nigerian Copyright Commission was established in 1989, pursuant to the Copyright Act of 1988, with the primary mandate of administration and enforcement of the copyright law of Nigeria. In a nutshell, the Copyright Commission has the powers of enforcement, powers of arrest, and powers of prosecution, and it's also expected to enlighten the public on copyright matters. Just a brief overview of the Nigerian creative industry. As you all know, we've got a very vibrant creative industry in Nigeria, and our film industry in particular, which I'm going to make reference to here, has gained international notoriety in the last 2 decades, and it's in fact ranked the second largest in the world in terms of production and the third largest in terms of economic value. With all the notoriety and the explosion in the film industry over the last 2 decades, it hasn't actually contributed as much to the GDP of Nigeria, and this is and the reason for this is mainly because of the issue of piracy. At the outset of 2012, the Nigerian Copyright Commission came up with a strategic plan of action and strategy on how to address this issue of piracy in Nigeria. And as part of that, we came up with key goals, which include proactive enforcement, vigorous prosecution, proactive enlightenment campaigns, and more importantly, establishing, deepening, and strengthening our partnership with the private sector, as we felt that was quite an important way we can actually achieve our mandate as a commission. I'm going to obviously give you some figures in the course of the dialogue of the achievements we've actually been able to record since through the public-private partnership. And the achievements have been due largely to our partnership with the private sector. We've established formal protocol with the IFPI, which has meant the administration of SID codes for locally produced optical disc, and this has really helped the Commission to monitor the activities of replicating plants in Nigeria, and it's actually helped to a great degree to reduce piracy quite significantly. I'm talking about local piracy. And we also believe in, obviously, the building and managing of value networks through extensive consultations with our stakeholders and relevant industry groups. So we hold regular consultation meetings with our stakeholders, get them to key into our enforcement plans for the quarter, and get their input on how they believe we can go about addressing this issue jointly. And it has meant us going and carrying out sensitization campaigns in very hotbeds of piracy. There's some markets in Nigeria which are well known for piracy activities. Most of you perhaps would have heard of Alaba International Market in Lagos, where it's a hub of piracy, and we have in the past 2 years managed to break into the market and carry out quite dangerous enforcement actions with the help of the private sector stakeholders. And this has yielded quite good results in terms of things we've removed from the market and in terms of convictions. But as I said, I'll fill you in on some of the figures during the dialogue. We also organize structured training programs for stakeholders, media practitioners and legal practitioners and the public. And we have a copyright institute that carries out all this training exercises for all the relevant groups. And this has really helped in terms of our public enlightenment and to make people aware of copyright matters. In addition, the Commission in the last 2 years has also been involved in consorting, as I said before, with private sectors, information sharing and intelligence gathering, which the private sector have been quite helpful in providing us with. And this has led to quite successful enforcement operations, because a lot of the information that we now obtain as a Commission before we're able to carry out our enforcement interventions is actually information coming from the private sector. So that has really helped. And it's led us to the interception of containers of pirated goods coming from Asia, specific reference to China. And I'll let you in on, I'll give you some figures on the quantum of seizures we have actually recorded over the last 2 years. Obviously, we haven't been able to do that without partnering with the Nigerian Customs Service, and they have been very supportive in this fight against piracy in terms of things coming in from outside. Beyond providing intelligence, the copyright owners also assist us in identifying the pirated goods. They train our copyright officers on how to distinguish between the pirated goods and the legitimate goods. So that's been quite useful. We receive training from the likes of Microsoft in how we distinguish between the pirated software and the genuine article. We've also created this or established the special copyright marshal scheme, whereby we have special marshals within the stakeholder groups that work along with the Commission in providing the information and intelligence, and they are actually giving the same powers as our copyright officers, powers of arrest and powers of enforcement. In fact, most of these copyright marshals actually accompany my officers when they are carrying out operations on the field. So this has been quite helpful, because the copyright officers are people who have been tested, and they are fit and proper people to hold these positions of copyright marshals. So that's helped a lot, and we've encouraged also our stakeholders to set up anti-piracy units within their companies, and this has really helped us in liaising directly with the anti-piracy units within the stakeholder groups. I'm going to obviously end by saying that the figures I'll provide you later would not have been achieved if we hadn't this close collaboration with our stakeholders in the private sector, and some of the figures are quite mind-blowing, and I'll be interested to fill you in on those figures, and as I said, in the course of the dialogue. Thank you very much.
Thank you, Director General Ezekude, for sharing with us these impressive results that have been achieved through the partnership of the Copyright Commission with the private stakeholders. Ms. Brell, please.
It works? Yeah. Okay, thank you. Good morning, everyone. Thank you, Mrs. Min. Thank you for the invitation, for being there today. I'm really glad to intervene as a representative of an internet platform, eBay. And I will speak about the collaborative and successful voluntary cooperation we had very recently experienced with private and the public stakeholders to protect the IP right in Europe. I will present you very briefly the background of what we call the Memorandum of Understanding, and I will explain you later what it is, what are the main principles of this MOU, the methodology that we have followed, and finally, what have been the outcome to date of this experience that we had. Very briefly, the background of what we call the MOU, background of the Memorandum of Understanding. It was a discussion initiated a few years ago by the European Union Commission, the DG Market, Margot Frolinger, to open a discussion with private stakeholders. And the purpose of this discussion was to fight against, to establish a code of practice in the fight against counterfeit over the internet. So this MOU has been signed 2 years ago now, in May 2011, and it has been signed by 17 right owners, 4 internet platforms, and 13 trade associations. Very quickly, what are the main principles of this MOU? On one hand, it's an obligation from the right owners to join the notice and takedown program of the internet platform, what we have at eBay, which is called the Vero Notice and Takedown Program. And on the internet platform, it was an obligation and a commitment to detect and to set up some measures to prevent the sales of counterfeited goods on our platforms. What was the methodology that we have followed for now 2 years? On one hand, we worked under the auspice of the European Union Commission, so we had very regular meetings, almost I would say every quarter, with all signatories of the MOU, so all private sectors and the EU Commission, to assess the progress made and to ensure that the communication and the dialogue open between the different stakeholders. And furthermore, in the top of that, we as a platform had very regular meetings and bilateral meetings with each right owners, signatory of the MOU. So the purpose of the meeting was really to exchange information, to see issues, to try to solve the situation with regard to the branded counterfeited product on the different platforms. And the purpose of that was, of course, to reduce the level of the counterfeited activity on eBay in particular. What was the outcome to date? So to summarize, I have released 5 words of the outcome and the results. So first one is dialogue, second one is engagement, trust, cooperation and efficiency. The MOU has really opened a dialogue that didn't exist, at least before some right owner and some internet platform. And the MOU has significantly improved communication between the different signatories. Second, about engagement. We as a platform, we engaged in a bilateral meeting with the vast majority of the right owners. And we have had some growing numbers of bilateral meetings between them and our platform. Trust, it was absolutely necessary, and it was a big outcome of this process, was to create a truthful and a very and a cooperative environment to open discussion and to open dialogue. As of today, all MOU signatories have signed up the Vero program at eBay, and most of them are using it on a very regular basis. The meeting, in combination with a consistent use of the Vero program, has allowed us as a platform to adapt our tools, to reduce, in some cases, and the level of counterfeit on our platform. So we have seen some efficiency with regard to this process. The role of the EU Commission, I would like to highlight this very important role where the EU Commission played on their initiative to open that dialogue and making sure that we work in a very fruitful and cooperative and trust environment.
Thank you very much, Ms. Frey, for sharing with us the efforts undertaken by the European Commission in partnership with the private stakeholders, and very interestingly, joining the forces of the the rights owners with the forces of the internet intermediaries to develop consensually a mechanism that would address the challenges brought forth by the internet, because of course we cannot talk about counterfeiting without addressing the rampant availability of counterfeit products on the internet. Next, I think we move on to the copyright side with Ms. Grant, please.
I'm very glad to be here and to be addressing you, and also would like to say this is really an amazing panel, a very diverse panel of participants, and I think our discussion later will be very informative based on the breakfast that we had earlier today. At the Motion Picture Association, obviously we have two areas of concern. One is the physical goods, the DVDs and so on, that are still being traded, very greatly across the world. But more and more our concern is what goes on the internet. And when we look at the internet issue, we really have to have a multifaceted approach to addressing it. Addressing the sites that are actually offering this digital content, addressing the intermediaries who support those sites, the advertising agencies, the advertising networks, the payment processors, the other people, other groups and entities that are actually facilitating the revenues going to those sites. But also another important audience to be addressed is the consumer who actually is going to those environments in the case of peer-to-peer or to those sites in the case of streaming and cyber lockers, and actually using those services. So there's a huge responsibility to educate consumers about the availability of legal content, but also to warn them of the issues associated with piracy. One of the primary intermediary groups that we work with very closely are the internet service providers across the world. And when one is approaching internet service providers, there are different approaches. You can have legislation, as we have in countries such as France or in South Korea or in Taiwan. You can have civil litigation, such as litigation that we recently had in Australia, and also including them in litigation, for example, in the UK around sites, bad sites. But another approach that we are now finding to be really effective is working with them on a voluntary basis. And I think that one of the reasons why this has become more possible is because internet service providers themselves are also content providers and content distributors, and they're realizing more and more that in order for their businesses to be successful, they need to be in partnership with the people that are actually producing that content in the first place. So one amazing example of a voluntary agreement that has been made recently is in the United States. And it's a memorandum of understanding between the five largest ISPs in the States, which are companies like AT&T and Verizon, and then the Motion Picture Association and the Recording Industry Association, and also the independent organizations that are in those two segments of the industry. This agreement was made in 2011, and the program that resulted from it was launched about 3 months ago. And the agreement provides for rights holders to send notices to the ISPs when they detect peer-to-peer infringement activity, people downloading and sharing files on the internet. And then the ISPs then forward those notices on to their subscribers when they figure out which subscriber deserves the notices. And the ISPs who are participating in this program and the content owners are all paying their own bills for the program. So it's a voluntary program which is funded jointly by the participants and not forcing anybody to pay anybody else's bills. The program didn't come overnight. It took us about 3 years to reach the agreement, starting from meetings with one ISP where literally everybody sat like this, not wanting to talk to each other, to 3 years or so later when we had all 5 ISPs really wanting to make this a successful program and wanting to do it in the most collaborative way possible. So as Catherine said, a lot of this success is about the building of respect, the understanding of the mutual concerns that we had together, but also our individual concerns, and actually really working hard technically, because technically it's a complicated process to get those notices to the ISPs and get the other parts of the program to work. One of the things that we did as part of the program is to set up the Center for Copyright Information. And this is an entity whose job is to kind of oversee the program and to monitor its effectiveness, but also is responsible for the education component of the program, which is website and direct engagement with consumers. And the Center for Copyright Information has a governance board which is composed of some of the members, but also has an advisory board, one of whose members is a very, very prominent consumer advocate, Gigi Sohn. And then we also have representatives from the privacy part of the world, and then also from technical sort of policy part of the world. So we really have tried through our board and through our advisory board to reflect again all the constituencies that are needed to make this a successful program going forward. Now, even though this is a voluntary program, I believe it would not have got to the end of its process and actually been implemented without the support of the US government, but also other entities in that arena. The initial discussions were sort of helped by now Governor Andrew Cuomo in New York, who, when he was Attorney General, was really concerned that internet service providers based in New York were not being responsible in terms of helping to protect copyright on their networks. But also he was concerned that films and music and other industries should still keep coming to his city. So he helped by starting to promote the discussions, and then they continued with the support of the White House and the intellectual property coordinator and others who didn't ever enter the discussion as a negotiator, but just stood behind us and had our backs, if you like, and said, we want this to work. And when it did work, then they applauded that effort. So again, a private partnership with public support, we believe is really effective in this area and something that we think could be replicated in other parts of the world.
Thank you, Marianne, for sharing with us this success story. I think it's really a very interesting model, and it's a model that complements the existing tools that I think most of this audience is very aware of, the civil procedures, the criminal procedures, the graduated responses, but that there are these other alternate options that can be developed and where each one of us has a role to play, I think. I think the people that you have mentioned, the government you've mentioned at the end, and then the private stakeholders, and of course, and I think it's really interesting how the intermediaries and the rights owners that traditionally have not been seen to be collaborative are collaborating together to create this success, and with the aim of protecting, I think you started out with the word consumers. So thank you. Next, we move on to Mr. Saab, please.
With all the discussions about the internet, my topic is with respect to domain name disputes. It's just one small piece of the problems that we face online. And it's a very good example of private, non-government cooperation, where basically the system entirely works through agreements between the parties, the people who obtain the registration, the people who are complaining about certain abuses of trademark rights. So it's a very good example of something that's been running and running effectively for well over a decade. Before jumping into UDRP, I'd like to first try to make reference to a couple things that I learned from the sessions before. On day one, we learned that the online counterfeiters and pirates, they continue to be elusive. Even through all the aggressive efforts to penalize them and very creative efforts to penalize counterfeiters, ultimately we see that it's very difficult to discover who they actually are and identify the individuals. And that's a reality that seems to still exist. On day two, we heard the very lively and very well-informed debate on cross-border issues. What is the proper venue? What laws should be applied? Does the court or the authority have competent jurisdiction over the subject matter as well as the parties? And those are very, very tough issues, and it's something that's going to be debated for a long time coming. The reason that I mentioned those points is that they tie in with, I guess you would say, the beauty of UDRP. There are no debates on jurisdiction. There are no national laws or questions about which laws should apply. There's one uniform body of rules and policy that's applied to all cases, regardless of the nationality or location of any of the parties involved. Okay? To give you a little bit of background on it, and by giving you background, you'll also see the limitations and applications. Obviously, this is not an effective enforcement tool that can be applied to every kind of situation. This proceeding came about, the main purpose of this administrative procedure and system was to address not counterfeiting, but domain name disputes. What I mean by domain name disputes is cyber squatting. People would obtain registrations that would incorporate other people's trademarks. Okay? So it was created to address that kind of specific situation. And because of that, the remedies that are available under this system are limited to cancellation of the domain name or transfer to the trademark owner. Okay? So this is not a system that's designed to punish or deter, and it's not a system that's designed to replace any existing options or remedies you may have under the local laws. And it should be viewed as an additional tool to consider, not to replace, but maybe also to implement together concurrently if it better enhances your objectives. Okay? So the limitation is this only applies in cases where the domain name, where counterfeiting or piracy is taking place, incorporates the trademark in the domain name. Okay? It sounds trivial, but I was actually a little bit surprised too, is when I dug into it a little bit, I understand that there was some unofficial survey done, and in a recent year, it was estimated that around 20% of the domain name cases included allegations of counterfeiting or infringement. Okay, so there are a lot of counterfeiters and pirates who use domain names, catchy domain names, to distribute unlawful goods. So with a website like fakebags.com, this would not apply because there's no trademark incorporated into the domain name. If the domain name were fakechanelbags.com, where the trademark is incorporated, then it would be applicable. Okay? Procedurally, it's very simple. The entire design of this was to resolve these type of disputes, but in a very efficient manner. So there's no court. It's not like litigation. You file a complaint. The governing body, and there are several different authorities that you can file the complaint with, and of course WIPO is one of them, and receives the most complaints. You file the complaint. Once it goes through the formal check, and the complaint is served on the respondent, they have 20 days to reply. Okay? And if they don't, then whether they do or they don't, the case is eventually passed on to a panelist to make a decision. And generally speaking, with the time frames involved, you can usually get a decision to get transfer of the subject domain name in maybe 6 to 8 weeks typically. So it's a very cost-efficient, very simple procedure with very predictable results because everybody's playing by exactly the same rules no matter where you are. I see that we're running out of time, so to shorten it, I won't go through the individual elements, but needless to say, there are 3 elements. The bad faith and the factor of whether the registrant has any kind of legitimate interest in the domain name. These second factors are pretty much negated when it involves counterfeit or piracy. Okay? So if it has a trademark in it, you should have a very good chance on all the elements. So that's a very easy issue. Once you win, what do you do with it? Once you take back the domain name, there are many things. Some people like to, some trademark owners, after they take it, they like to forward it to their own official site. I'm not sure how many, people who are looking for counterfeits will then go on to purchasing genuine goods. That's not clear. I haven't heard any studies of it, but that's one thing that's done. Another interesting thing that can be done is once you've taken over the domain name, unlike other civil or criminal remedies, you own the domain name and you're getting indirect access to the counterfeiter's customers. All the people who are going to this site are going to keep visiting it while you've taken control of the domain name. So you can use that opportunity to post certain messages. You know, this site was involved with illegal activity, it's unlawful, it's a crime, and then forward them to your official site. Another thing that you could do is there are a lot of good analytic tools. Once you take the domain name, you can watch how many visitors are coming to the site. How active was this? Was it only one visitor per month? In which case, you know, it's not such an important matter. It gives you some insight. On the other hand, if you're getting 100,000 hits per day, you know that this was quite a serious problem. And you can also look at where the visitors are coming from which region, and all that could offer you some insight. So in conclusion, it's a very good system that works consistently, reliably, and it's been in place for a long time, and it can be a useful tool to incorporate in very specific types of cases. Thank you.
Thank you, Iken, for sharing your experience with the Uniform Domain Name Dispute Resolution Policy. Of course, it's a policy where WIPO had a very important role in developing. When WIPO started the internet process back in 1998, it was an experiment, I think. We took input from member states, all the stakeholders, from consumers, academia, and we came up with a recommendation. That recommendation, developed through a more public process, was passed on to a private entity that manages the technical aspects of the domain name system. And now WIPO is providing services under this policy. So that partnership, I think, is very symbolic. And I think another message that I would like to draw out of your introductory statement is when we enforce IP rights, what are the remedies we're seeking? You rightly point out that on the first day, many presenters were talking about takedown. If you want a takedown, a quick takedown, do you want to go through a very heavy civil procedure that might last 3 years? No, you want a quick, cheap, global process. So let's try to develop, in collaboration, such a process. I think that's a very good symbol. Now, last but not least, Mr. Mahdi, thank you.
Merci. Bonjour, mesdames et messieurs. C'est un plaisir pour moi d'être présent parmi vous pendant ces 3 jours du Congrès mondial de la lutte contre la contrefaçon et le piratage, organisé dans une des plus anciennes et plus splendides villes du monde, Istanbul. Donc, il est vrai que la contrefaçon n'épargne malheureusement aucun secteur. Les cibles de la contrefaçon varient entre les vêtements, les logiciels, et passant par les médicaments, les cosmétiques et allant même au matériel informatique. À peine un siècle en arrière, ce phénomène touchait seulement les livres, les boissons, les vêtements, mais actuellement, avec le progrès technologique, la globalisation, les canaux de distribution se sont largement développés et il est devenu aisé de copier et de reproduire différents produits identiques aux vrais, ne serait-ce qu'en apparence. Il est donc pas rare de se trouver avec un faux produit, qu'il soit un jouet pour enfants, une pièce de rechange pour une voiture, ou même un médicament pour un cancer. Les ventes via les sites marchands ont contribué à la prolifération de ces produits contrefaits. La contrefaçon ne nuit pas seulement aux entreprises ou à ces marques. Elle est un véritable fléau pour l'économie nationale et internationale. Il est un fléau, il impacte aussi la vie sanitaire et sécuritaire du citoyen. Le consommateur ne sort pas indemne de ce jeu. Il paie plus que tous le prix de cette concurrence déloyale. Le consommateur souffre de la contrefaçon et spécifiquement quand cela touche sa santé et sa sécurité. La contrefaçon a des aspects négatifs et nous les déclinons principalement sur 2 axes. Le premier axe, c'est l'aspect sanitaire et surtout le secteur pharmaceutique, médical ou paramédical témoigne d'un chiffre fort alarmant et des études estiment que plus de 10% des médicaments vendus dans le monde sont contrefaits. Le problème découle du fait qu'un faux médicament peut être sous-dosé ou être basé d'eau, de robinet, de sucre, du café, ou même contenir des substances dangereuses pour les patients. Sur l'aspect sécuritaire, on constate que les jouets mis en vente ressemblent fortement aux jouets originaux et trompent ainsi facilement beaucoup de consommateurs. La contrefaçon touche aussi les secteurs, les pièces de rechange qui ont une courte durée de vie, comme les pneus, les phares et les pièces d'électrique. Ces pièces sont standardisées et conviennent à beaucoup de modèles de voitures et ont un coût unitaire bas vu l'absence du système sécurité. Quand le consommateur lambda parle de la contrefaçon, les premières choses qui lui viennent à l'esprit sont des sacs Louis Vuitton, des ceintures Dolce Vita ou Dolce Gabbana ou encore des jeans Levi's. L'aspect de la dangerosité est mal connu de la part du consommateur. Le risque encouru en achetant un produit contrefait est très important. Ce risque est accouru du fait que le consommateur ignore la nature falsifiée du produit et le consommateur peut être victime de la contrefaçon. D'une façon globale, c'est le consommateur qui paye le prix de cette concurrence déloyale, même si la plupart des consommateurs ont le sentiment de faire une bonne affaire. Le point commun des produits contrefaits est que le consommateur n'a aucun droit de recours contre le producteur de l'article véritable et n'a pas non plus de chance de toucher des dommages et intérêts de la part du contrefaiseur ou du distributeur. Une fois de plus, le consommateur est victime de ce cercle infernal. Le partenariat public-privé doit s'élargir pour comprendre les associations du consommateur et le secteur public, précisément, a le devoir d'informer le consommateur. Le consommateur est peu sensible aux campagnes de lutte contre la contrefaçon et les campagnes qui communiquent sur les peines pécuniaires et sur les risques de faillite des entreprises. Ce sont ces derniers de ses soucis. Les campagnes de sensibilisation doivent s'articuler sur des éléments sensibles, palpables et mesurables par lui-même. Ces attentes et les attentes des associations de consommateurs sont plus dans l'esprit d'un réel partenariat pour la lutte contre les produits qui nuisent à sa santé et à sa sécurité. On se demande certainement que font les associations de consommateurs au Maroc pour lutter contre tous les fléaux qui nuisent à la santé et à la sécurité des consommateurs. Alors, permettez-moi de partager avec vous une nouvelle que je viens de recevoir ce jour même. Il s'agit d'une association qui appartient à notre fédération et qui vient de finaliser un projet de campagne de sensibilisation contre l'utilisation des pièces de rechange de véhicules contrefaits. L'OMPIC, l'organisation ou l'organisme de la propriété industrielle et commerciale du Maroc, est disposé à soutenir cette action. Je crois que cet exemple explique clairement le rôle que peuvent jouer les associations de consommateurs dans le cadre de la transmission d'une information claire, transparente, sans autant toucher la mission principale qui est la défense des intérêts économiques du consommateur. Je vous remercie de votre attention et vous remercie encore de m'accorder votre temps. Merci encore.
Thank you, Mr. Mahdi, for reminding us that counterfeiting does not only affect the rights owners, the industry, but in the end, it's the consumers that pay the price. And I'm particularly delighted to hear the news that it was announced today that the Moroccan IP office will work with the Consumer Association in this fight against counterfeiting, and I hope this type of model can reverberate in other parts of the world. We had a very interesting discussion this morning over breakfast. It was very lively, and I think there were certain questions, concerns to be shared, the way forward, how can this experience be reviewed to contribute to the IP system really achieving its aim. And the question that came up, one of the questions, I think, is what are some of the concrete results that can be achieved through public-private partnership that would have been much more difficult to achieve without such partnership? And maybe I'll start with Director General Ezekude.
Thank you very much for that question. And as I said in my opening remarks, I will provide you with the sort of achievements we've recorded in the last 2 years at the Nigerian Copyright Commission. From 2011 to date, we have carried out a total of 108 strategic anti-piracy operations, and that has led to the removal of 4.5 million quantities of pirated copyright works from the marketplace. And the estimated street value of these removals comes to about 4.7 billion naira. And if you convert that into US dollars, it comes to close to about 40 million US dollars, which is quite a considerable amount of pirated items removed from the markets in Nigeria. Out of the 4.5 million in terms of quantum of seizures, there were 16 containers that were intercepted at various ports, seaports in Nigeria, and 11 of those containers were actually carrying pirated books from China. And I don't think we would have been able, the only way we were able to intercept those containers was the intelligence and information provided to us by the Nigerian Publishers Association. And with that intelligence, we obviously worked alongside the Nigerian Customs Service, and we were able to intercept and seize those 11 containers of pirated books from China. And I must say that those books, when we looked at the books and compared them with the legitimate items, those books were actually very good quality. And that's very worrying. We obviously intend to address those sort of issues by perhaps importing the technology so that our local publishers can actually produce books of such quality. But those books, as I said, had been removed, and we also, as part of the enforcement, as part of our prosecutory activities, we managed in the last 18 months to secure a total of 32 criminal convictions, and some of those convictions, the punishments meted out by the courts were quite severe. So we're hoping that that would serve as a deterrent to pirates not to engage in these sort of criminal activities. As I said, I don't think we would have been able to achieve all this without the relevant intelligence and information being provided to us by the relevant private sector stakeholder groups. So that goes to show that the public-private partnership and between the Nigerian Copyright Commission and its stakeholders, it's really, in real terms, yielding the sort of results that we like to see when we talk about the fight against piracy. There's no other way we would have been able to achieve it, because this is the first time in the history of this commission that we are achieving, or obviously we're intercepting things at the ports, and our working relationship and partnership with the stakeholders is really, it's really something we cherish and will continue to pursue. Thank you.
Thank you very much. These are really impressive numbers, I must say. But I remain puzzled. I remain puzzled in particular by what Marianne had mentioned, that the internet intermediaries enter in these partnerships at their own costs, because the intermediaries are not protecting their own brands, right? They're using their budget to protect the brands of other companies. How does that happen?
It's unusual, and again, what we were able to achieve in the States is unusual, but I think it's not going to be the only time it'll happen. And I think there were several reasons for it. I mean, first of all, as I mentioned already, internet service providers' businesses are actually content businesses too. They're certainly distributing content, but a lot of times they're making it, or they are in partnership with legitimate organizations who want their content offered that way. So there's definitely a business interest there. But I think secondly, there's something about it's the right thing to do in some cases. And it's the right thing to do because of the bigger picture, not just the smaller picture of a particular film or a particular piece of music or something like that. It's about responsibility on the internet. And I think internet service providers are beginning to see more and more that their responsibility is to educate their consumers about responsible use of that environment, that environment is just a place to be responsible as the physical environment is a place to be responsible. And then I think the third part of it is, when you look at the size of these organizations, they're very, very large organizations, and the investment that they made in this program is significant for the technology, but it's not overwhelming their businesses. So if you kind of balance, and they also understood more what the rights holders have to do for our side of the equation, which is extremely significant. So I think all of those things together helped us to get to the decision. But again, it's a model I think that we can take elsewhere, and we can use not just the nice-to-have proof of it, but also the real meat of why and how and what the value is on the better performance of network, on the better availability and accessibility of legal content through those networks, etc., to kind of underline the value proposition going forward.
Thank you, Marianne. I think there must be something, because if the U.S. Center for Copyright Information was established in parallel with all the debate going on with SOPA and PIPA, Stop Online Piracy Act and Protect IP Act, you may recall, some of you may recall about a year ago, is it, where Wikipedia just shut down in opposition to these acts, and in the meantime, you managed through dialogue to achieve the success. But in case of eBay, because eBay has been over years spending a lot of money to protect IP, other companies' IP, what are the motivations?
The motivation of the MOU was really to create a dialogue, because even if we had and we implemented years ago some measures to fight against counterfeit, it was absolutely necessary to work more closely with right owners, to understand the trends, some issues, some specific concern that they may have that could be useful for our company to better and to improve our tools and our own methodology internally to the fight against counterfeit. So the dialogue was really something for which we expected a lot, thanks to the MOU. And so create trust and dialogue was really key. And before the MOU, we had no relationship with some very key right owners. So this MOU allowed us to, and some key right owners, to create a dialogue that didn't exist at all before.
Thank you. So I think it's really showing that everyone is trying, everybody is pitching in. And what about the results? Maybe Ikhyun, as a private practitioner, often directly involved in enforcing IP rights, do you see any advantages brought forth by these the softer mechanisms, these voluntary mechanisms?
Absolutely necessary. The reality is that the laws and the courts lag far behind the pace of actual business. And so we're constantly facing new issues online with eBay through all the litigation throughout the world. Because we don't have the framework there, legal framework there, if you want to achieve something in a predictable manner, I think that this kind of cooperation between right holders, stakeholders, is absolutely necessary to solve the problem. Otherwise, there's nothing you can do except keep litigating it and hope legislators come up with new laws. But you have to do something in the meantime. So I think this is absolutely the approach to take. And the UDRP proceedings are a very good example. It was it was through private cooperation, not through national legislation, that you created the system. For example, in Korea, the right to demand transfer of a domain name did not even come about until about 1 or 2 years ago. You could make an assertion. A few years ago, there was a new law that was created to address domain names, but the law only allowed for cancellation. It didn't allow for transfer. So you can see that even for Korea, one of the most wired nations in the world, and where online transactions surpassed, store transactions many years ago, even in a nation that powered and driven by the internet, the laws on domain names was still lagging 6, 7, 8 years behind what was created through UDRP. So that's another very good example of cooperation preceding and addressing issues faster than legislators or the courts.
Thank you, Ken. I think that's a very valid point. And so when we look at the different enforcement mechanisms, I guess it's a bit like a pyramid. So at the top, you would have the laws. And then at the bottom, maybe there are these contractual terms, like eBay's contractual terms, for example, and there can be some mechanisms to protect IP. And in the middle, perhaps, there are these voluntary mechanisms. And these voluntary mechanisms can be developed in a more flexible manner, more timely manner, provide a remedy that the laws were not providing, gather experience, and through that experience, the law can be enacted. And I think the experience that you shared in Korea, that the transfer of the domain name remedy came through after 10 years of UDRP experience that got translated into national law is very, very good. So thank you very much. But the consumers. So everybody has a role. Now, what is the role of consumers in this debate? The role of consumers, the role of the associations of consumers.
Écoutez, le rôle des associations de consommateurs, il est très clair. C'est-à-dire que si on veut défendre, nous, en tant que mouvement consumériste, le droit du consommateur, c'est qu'on doit le voir de 3 angles. C'est-à-dire le premier angle principal, c'est de défendre le consommateur, surtout dans ses intérêts économiques, et ça c'est le plus important. Puis après vient le secteur ou bien l'ordre sécuritaire et sanitaire, et ça là où on peut, disons, collaborer et trouver des moyens de partenariat, mais comme je venais de le souligner tout à l'heure, c'est un partenariat. Il faut savoir que le consommateur aussi, c'est un partenaire incontournable dans l'économie de chaque pays. Donc, il faut le prendre comme un interlocuteur sérieux, un interlocuteur disons, d'une grande importance, parce qu'en finalité, nous produisons ou le fournisseur produit pour vendre à ce consommateur-là. Donc l'exemple, par exemple, au Maroc que nous vivons actuellement, et notamment avec le programme Campiac que le ministère a mis en place, c'est un programme qui est quand même très, disons, important, et que les associations de consommateurs sont invitées d'y participer. Et en écoutant le consommateur, nous pouvons justement remédier à beaucoup de choses. Donc il ne faut jamais dire que le consommateur ou les associations de consommateurs sont entre parenthèses des ennemis, mais il faut les prendre comme des partenaires et discuter de la chose pour pouvoir en aller de l'avant. Il faut savoir aussi que si nous produisons, si le fournisseur produit, c'est justement pour pouvoir vendre aux consommateurs. Donc chacun de nous, dans notre intérieur, on est, que ce soit consommateur ou fournisseur, on est obligatoirement un consommateur de n'importe quel produit.
Thank you very much. I think I could just go on asking questions, but I should probably open up the floor for any questions. Yes, please.
Hi, good afternoon. Thank you for recognizing me. I had the unpleasant distinction of being the only person who wanted to ask a question yesterday, but I wasn't called. So with that on record, I'd like to introduce myself. I'm Cyrus Valenzuela. I'm a lawyer from the Philippines, and I head a government agency tasked with regulating optical media. When the Optical Media Act of the Philippines was enacted in 2006, one of the problems the legislators tried to address with this law was the problem of the copyright owners or the brand owners not wanting to file the necessary cases in courts. As you understand, IP is a private crime requiring a private complainant before the courts can actually hear cases. The Optical Media Act made it possible for the Optical Media Board itself to act as the complainant for violation of its law. So we regulate not just the pirated optical media, but the originals as well. So any violation of our act, the OMB can actually go to court and file the necessary case without waiting for the copyright owner to file a case. So with that, I would like to ask the panelists the importance of public-private partnership in the context that if we talk about a partnership, we are talking about entities with mutual needs or with mutual goals. However, as I would understand, copyright and brand owners have different agendas with government and its enforcers. Governments would like to prosecute law violators, whereas the brand owners and the copyright owners are concerned with their reputation and with profits. So would there really be a real partnership in that context? And is there any way to how do you call this? Because for example, in the case of Microsoft,
I think just for the interest of time, I think if I may just summarize the question. Different like brand owners have their own interests to protect. These actors have different interests to protect different agendas. I think is the word that you used. How do we reconcile these different agendas?
Thank you.
Any volunteers? Marianne?
I think your point is really good, that everybody is going to look at this in different ways. But I think that, first of all, you have to consider the context of it. So, if somebody is doing something that's blatantly illegal and importing large quantities of product or something like that, it's easy for a brand owner to say, that's my stuff, they need to be put into prison. But it's very different when you're talking about something like, downloading on the internet, and it's, the granny's grandchild in the basement who's doing it, and are you going to lock up the granny? Probably not. So I think that there's, first of all, brand owners are continually now having to consider the context and having to consider, do consumers actually understand, or are they going to understand, why this happened? And so I think that's a very big thing now. It certainly is for our members. They're continually assessing, their position in the community, as well as their willingness or their wish, their desire to protect their copyright. The other thing, frankly, I think what Mr. Sao said before is that sometimes the legislation that you're using or the law that you're using to do this may not be the best. And again, in the world that I work, some of the laws that have been passed about online activity and so on, or what ISPs are supposed to do, or what others are supposed to do, may not be as practical as they could be, maybe not be as helpful as they could be. So you can find yourself actually supporting or having to use something which maybe is not going to yield the result that you really are trying to get. So, and again, would make you, as a brand owner, be less kind of respected, I guess, in the community. So I think that there's a balance. So we want laws that are good laws. We want to protect our copyright, but we also want to make sure, particularly on the consumer side of things, that people will see it as being a fair process with due process and not something that is draconian.
Thank you very much, Marianne. I realize that time is running out, so maybe we could just have a final round of comments, 10 seconds per speaker. If there is one message that you would like to get out through this panel, please. I think this time we'll start with Mr. Madi.
Le message que je voudrais transmettre justement à l'honorable assistance, c'est que la protection du consommateur et surtout au niveau du Maroc, c'est quand même très important de savoir que nous sommes ici pour pouvoir transmettre un message de sécurité, et je reviens toujours à le dire et le redire, je n'arrêterai jamais ça. Donc le message le plus important pour nous, c'est un message sécuritaire et sanitaire pour le consommateur. Du moment que nous voyons que le consommateur est affecté par une utilisation frauduleuse ou une utilisation d'un produit qui touche à sa santé, et je peux vous dire que c'est vraiment le cas de plusieurs personnes, ou bien à la sécurité, et c'est aussi le cas des accidents qui peuvent arriver pour les bébés ou pour les enfants qui n'ont aucun pouvoir de pouvoir se défendre. Nous sommes là pour pouvoir les défendre et nous utilisons tous les moyens pour pouvoir les défendre.
Thank you. I just need to mention that we have our Deputy Minister sitting in front of us, so 10 seconds. Thank you.
Life is not perfect. When it comes to enforcement, I'm a strong believer in taking action that provides deterrence. But reality is we don't always have all the budget to do everything as aggressively as we wish. So I think taking a holistic approach is probably the best. Weigh all your options and take the step that's commensurate to the circumstances that you have.
Use all the tools in your toolkit, which include legislation and include the civil side of things. But secondly, involve the people who really know how this might work. And if they actually talk to each other and they learn to respect each other, they'll come up with a solution that will actually work.
I would like to say that this kind of process is really a win-win for both private and public stakeholders. In particular for us, internet platform and the right holders, and at the end for the consumer as well. So it's really a win-win. So for me, it's the key message for everyone around the table. And I will give another message would be we could take our successful collaboration with the MOU and the EU Commission to say we can broaden the scope to other sectors, very similar sectors, not only internet platform, but there are some other sectors within even internet, like social media, etc., where we know that the discussion and with the right owners and search engine, etc., could be difficult. So it could be used as an incentive for that.
Yes, I would like to conclude by saying that public-private partnership is a very effective tool in relation to the fight against piracy, and it has worked magnificently for the Nigerian Copyright Commission, and I think it will be an effective tool for all other agencies tasked with similar responsibilities all over the world. Thank you.
Thank you very much. If I may summarize just in 2 sentences what I've learned from this panel, that intellectual property is not an end in itself, but it's an instrument to achieve social interests, and we need to use all the tools that we have at hand. It can be law, it can be infrastructure, it can be cultural change, awareness raising, international collaboration, it can be business tools, technology tools, legal tools, and I think it is through the combined ingenuity that has been represented on this panel that we can work towards that goal. Thank you very much. Thank you.
Thank you to the panel. and we will move on.
Thank you very much.
Now I would like to give the floor to His Excellency, Deputy Minister of Customs and Trade of Turkey, Fatih Metin, to make his special address. Şimdi sözü Gümrük ve Ticaret Bakan Yardımcımız Sayın Fatih Metin'e bırakıyorum. Buyurun Sayın Bakan.